Good afternoon, everyone. Thank you for joining us. My name is Jacqueline Bird. I am the BOMA Greater Dallas Secretary Treasurer, and I'll be your moderator for today's webinar discussing your questions about the Coronavirus Aid, Relief, and Economic Security Act, more commonly known as the CARES Act. This is aimed at providing economic relief to individuals and businesses negatively impacted by COVID-19. This is a great opportunity for all of us to learn. But before we get started, I want to thank our BOMA Greater Dallas Cornerstone partners for their support. April Building Services and AMST Elevator Interiors, Interstate Restoration, LandCare, and Mooring Construction and Restoration. Our speaker for today's webinar is BOMA Greater Dallas's legal counsel, Tony Barbieri, shareholder with Kessler Collins. While Tony will cover legal issues, this is not legal advice. Further, due to the rapidly changing nature of the law and the COVID-19 crisis, we recommend you consult with your legal counsel on this issue before you implement or change any policies or procedures. And finally, this session is being recorded so we can share it with members who were unable to join us. Now, on to our discussion. Good afternoon, Tony.
Good afternoon, Jacqueline. How are you doing?
I'm doing great. It's good to see you again.
Likewise, likewise.
Yeah. Listen, we received so many questions with the registrations, and I anticipate we probably won't get to, we'll probably get more of them during the call. And I know you're going to try to answer as many as possible, but I also realize it's likely you won't be able to get to all of them during this session. Nonetheless, I'd like for us to try as many as we can.
Yeah, that'd be great. Let's go through it. Looking forward to it.
Cool. Well, one of the questions that came up from the registrations had to do with industrial property managers, and they wanted to know that if industrial property managers are at risk if they don't inform other tenants that certain tenant employees have tested positive for COVID-19.
Yeah, this is really a great question. And it's kind of a loaded question. And I'll tell you that the response I'm going to give you is going to apply to not only industrial property managers, but I would say pretty much all commercial building owners. First and foremost, there's no specific law that says that as a property manager or owner, you have to notify your building occupants if somebody in the building tests positive. Mm-hmm. But it is a good idea to do so. And I say it's a good idea to do so because as a building owner or manager, you have a duty to keep your tenants and their guests safe from, reasonably safe from harms that you are aware of. Mm-hmm. And if you are aware of a dangerous condition in the premises or in the building, I should say, then you should notify the tenants. Now, there's a lot of caveats to this because there are other laws at play. And without getting too bogged down on that, I just want to point out, you never want to identify the employee that has tested positive. So never identify them by name and don't identify them by company. If you are in a building, this probably won't apply to most industrial buildings, but if you're in a building where there are multiple floors, it is okay to notify specifically everyone on that floor that someone on your floor has tested positive, as opposed to a general announcement that someone in the building has tested positive. But I would not identify the actual tenant involved, and certainly, like I said, don't identify the actual employee. But once you put everybody on notice, then it's imperative to have close communication with that specific tenant who initially told you about the employee that tested positive. You want to find out, for example, make sure that person is being quarantined and following the CDC guidelines. You also want to make sure that no one else in that tenant's workforce has any symptoms or has tested positive. And you want to make sure that to the extent that tenant is required to comply with the cleaning obligations in their lease, that they do so. A question has come up as far as cleaning the common areas. Mm-hmm. Typically, now this depends on a couple of factors. Specifically, it depends on what type of common areas you have. If the common areas are big areas like an office building or retail setting where people can sit down and and congregate, then that definitely needs to be cleaned up, and you should definitely stop people from congregating in the buildings, because in the common areas, because that does not comply with the social distancing guidelines that we have in place across America. But nevertheless, you still want to go ahead and do a deep cleaning of the common areas. And again, there's certain protocols to follow for that. And then I would also, the next question that most clients are asking me is that expense included in operating expenses? And again, that's going to depend on your lease.
Okay, good deal. Thank you.
Sure.
Let's jump into some questions that are more directly related to the CARES Act itself. A question that came up, someone wanted to know if there were any interesting stipulations or unusual requirements for companies that take the available loans or grants that are available by the CARES Act.
Yeah, so the CARES Act that was just passed 2 weeks ago is the largest stimulus bill that our country, probably the world, has ever passed. It's essentially a $4 trillion bill that provides relief to everyone from unemployed folks to airlines and everyone in between, seemingly. And so if you could imagine all the, when the government's giving out $4 trillion of money, there's a lot of hooks and caveats that go with that. I will say this, though, considering how quickly the government responded to this crisis and how quickly they put this law out, it's surprisingly simple, which I know might sound like a contradiction of terms when you're talking about government legislation, but considering what we're dealing with, it is fairly simple, although it's not very clear. When you draft something that quickly, there are a lot of things that they did not really specify. So I would say there are a lot of questions that we're getting asked by employees, and it's hard to answer because there really aren't any regulations in place. Ordinarily, when the federal government has a law that it enacts, the law is vetted for at least several months or a couple years. There's lots of input from the community, and so they try and fine tune the law, and then the federal government typically puts out a separate set of regulations to help you interpret the law, and we simply don't have any of that with this statute. So there are tons of hooks and things in it to keep in mind. Essentially, like I said, the CARES Act has a lot of different relief, a lot of different stimulus for many different types of businesses. What most of us have been hearing about recently is are three things. One is the expansion, the benefits for unemployed workers, which they greatly expanded, including a $600 per week increase in the benefits for up to 4 months. And also additional federal funding to states for various unemployed benefits. There's also the $350 billion payroll protection program, which I'll call the PPP, and I'll get to more detail later about that. And that applies to pretty much all employers as long as they have up to 500 employees. There are some exceptions to that. For example, restaurant companies who have more than 500 employees are exempted from that requirement, and it's meant to impact obviously economic hardships as a result of the pandemic. Then the other component of the CARES Act that most of us are familiar with is the recovery rebate for individual taxpayers. This is essentially a stipend, $1,200 for individuals, $2,400 for joint taxpayers, that the government is issuing just to anybody. However, there is a phase out for certain people with income above various levels. So with that, there's like I said, a lot of restrictions. For one, the PPP, the payroll protection program, it is intended to fund your payroll for up to either $10 million or 2.5 times your average monthly payroll. And when they're looking at the average, they're looking at January and February of this year. Like I said, it's available for employers up to 500 employees with a couple of exceptions. The other interesting thing about this is the payroll protection program is a loan, but there is a forgiveness component to it. What I mean is that the loan can be either totally forgiven by the federal government or partially forgiven by the federal government. And this has caused probably the greatest area of confusion as far as what is forgiven and what is not forgiven. Generally speaking, if you comply with the loan requirements, the entire amount you take out is forgiven. If you do not comply with the loan requirements, it doesn't mean that the whole loan has to be paid back, but it could reduce the amount of forgiveness. In other words, if you only partially comply, then some of the loan will have to be paid back. If depending on how out of compliance you are, you may end up having to pay back the entire loan. However, the loan can be paid back up to 10 years, depending on the bank that you get the loan through, and it's capped at 4% interest rate. Another interesting feature is that the loan is not required to be guaranteed by the business owners themselves, and there's no collateral involved. So those are all definitely unique and interesting situations for any type of loan. Keep in mind, these loans are going through the government's existing SBA, Small Business Administration loan process. And so a lot of those rules apply, but government made specific exceptions, some of which I just rattled off to you, to specifically apply for the PPP.
Awesome. That's a lot of great information. I'm glad that you understand it the way that you do. It's hard for a lot of us to really get our hands around it. So this is great information.
Before you go on, one of the really key points, I didn't mean to cut you off, but I do want to point out to you is that not 100% of the wages are covered by the PPP. Typically, well, let me just start by saying that salary, wages, any commissions that are typically paid to folks, and then tips for those people in the service business. Those are part of what can be used for the PPP program, but it is capped at $100,000. So if you have an employee who's making $120,000, only the first 100 of that is capped. Also, you can get some component of additional benefits that you have for your employees baked into the loan. For example, it can cover certain PTO, family medical leave, et cetera. And you could also include some of your federal and state employment taxes as well. Sorry, go ahead.
No worries. How does the CARES Act benefit large public companies?
Well, there is a separate component of the CARES Act that has billions of dollars set aside specifically for public companies. Some of them are in very specific industries like the airline industry or other infrastructure companies. But there are a lot of opportunities for even big companies and publicly traded companies to have benefits of these loan programs. But unlike the PPP loan, these loans must be paid back. There's no forgiveness component to the loans for corporations. And there are a lot of other restrictions to these loans. So for example, the corporation is prohibited from buying back its own stock. Those of you who were around during the Great Recession will recall that a lot of these big companies that got the bailout used the money to buy back their stock, which did nothing but increase the value of the stock and benefited the shareholders. So the loans that have been enacted for big corporations under the CARES Act prohibits the corporation from buying back its corporate stock for the longer of the length of the loan or 12-month period. And then on top of that, the corporation cannot make distributions on its stock for the same time period. There's also limits to compensation. The shareholders, the officers of the company or any employees of these companies, they're going to have to go in and cap their salaries depending on how much they made in 2019. There's a couple different thresholds. For example, if you were an officer or employee who made more than $425,000 in 2019, then you have to cap your compensation under these loans. And so there's a couple other thresholds like that as well. But yes, these loans are out there. I encourage you to tell your tenants about them if they don't know about them. I think most larger corporations are aware of the bigger loans. But I've seen a lot of clients who are smaller companies who aren't aware that the CARES Act could actually benefit them in their business itself.
You know, one of the registrants mentioned that they have a lot of small businesses in their building. And so some buildings have small tenants, some buildings have larger tenants. How does the CARES Act offer them actual relief to the tenant when we look at it from that perspective?
Yeah, well, and that's exactly what I'm talking about. A lot of the smaller clients, especially, for example, doctor's office, dentists, etc., smaller restaurants, they definitely can benefit from this package. But a lot of the smaller companies, just because of lack of sophistication or awareness, don't know that these loans are out there, and they don't know how to go about getting them. And so, frankly, if I could just back up real quick, when my clients are being approached by tenants for rent relief, rent abatement, the landlord is telling them, well, before we can consider your rent relief, have you looked at any of these loans, see if they're available to you. So make sure your tenants are aware that they're out there. As far as your specific question, how do they benefit the small tenants? Well, the PPP, the Payroll Protection Program, definitely helps the smaller tenants, because it frees up capital and provides liquidity so they can pay their employees to keep them around, which also frees up capital to pay your other expenses, including your landlord. And part of even though the payroll protection program is intended to pay employees, you can use certain percentages of it. You can use up to 25% for non-payroll expenses, which includes rent. And so, rent is one of the expenses that is specifically allowed to be paid by tenants when they get their PPP loans. And when you calculate how much you're eligible to receive under the PPP program, the PPP, then that part of what you calculate is some of your eligible rent expenses. One other thing that I want to point out, a lot of your smaller tenants may already have existing SBA loans, and part of the CARES Act, it expanded some of the loans available, and it loosened some of the restrictions on the existing SBA loans. A lot of the smaller tenants may not be aware of that. Some of these rules get fairly complicated, but you might want to also notify your smaller tenants to tell them, hey, if you already have an existing SBA loan, have you talked to your SBA lender about that loan to see if there's any additional relief for you there?
Yeah. You know, when we talk about the CARES Act, the question came up that if a company already laid off its employees, could they actually go back and hire them back and then file under the CARES Act?
Yeah, you can. You can still file under the CARES Act, but you have to rehire those employees back by June 30th. Correct.
And of course, the exact same employees that were there.
Yeah, the exact same. Yeah, exact same employees, or replace if they're no longer available because they've taken other work. Then if you can replace them, then that's sufficient. Yeah. Replace them with a comparable employee, I should say.
Yes. Fielding a question that's come up. It's asked, if the tenant has asked the landlord for rent abatement, deferral, or reduction, can they still get the payroll protection program turned into a grant if they're not paying full rent?
Yeah, this question has come up a lot. And so this goes back to the forgiveness component of the payroll protection program. And part of that component is if you pay all of your rent through June 30th, to the extent that you got the loan, and if when you applied for your loan, if you included rent in that loan, and you got the loan the loan was funded, you have to pay your rent through June 30th. So if you take an abatement of rent and you get the loan, you have to pay back the rent that was abated prior to June 30th. So for example, April rent is obviously now due, and so tenants who have applied for the loan, which by the way, the loan application started last Friday, so people are still applying for it now. So if you have not paid your April rent and your landlord says, I will abate your April rent, and then you get the loan in a couple weeks, the loan will be forgiven if you subsequently pay April rent before June 30. Let's say you don't pay April or May rent, and you still get the loan, you would have to pay April and May rent before June 30th. If you do pay rent and you're caught up by June 30th, then the loan turns into a grant with respect to the rent. And that's what I talked about. This is one of the things I was mentioning earlier, where there's partial forgiveness. So let's say hypothetically, you took the full loan that you could get, you did not lay off or restrict or cut any of your employees' salaries, but yet you did not pay April rent. If you never went and paid April rent, and then July 1 rolls around, there would be a partial forgiveness reduction for the April rent that you didn't pay.
Okay. I don't want to throw a wrench in it, but I guess the question that comes up is, you mentioned if they don't pay the April rent, how does that get married up? Do you know? The idea is this: a tenant could not pay their April rent, get the benefits of the CARES Act, pay everything else, but not pay the April rent. How do?
Yeah, well, if they paid everything else but the April rent, then that April rent, that component of the payroll protection program loan they got would not be forgiven. They would have to pay that part back. Does that make sense?
Yes.
Okay.
Do you know if there's an anticipated distribution date for the individual stimulus payments?
The individual stimulus payments are supposed to be funded starting today, April 9th. Now, the government said they're going to start funding it today. I don't know. No one's really clarified what that means as far as when everyone's going to start getting their payments, but supposedly they're starting it today.
Okay. Is there anything behind the second round of stimulus for small businesses?
Yeah, so one of the big questions is whether or not there's going to be enough stimulus money available for small businesses, specifically the payroll protection program. And no one really knows when all these shelter-in-place orders and lockdowns and whatnot are going to expire. So the question is there going to be more stimulus? Are they going to run out of stimulus? I know that President Trump has been rather vociferous about telling everyone that he's going to make more money available. And I know Secretary Mnuchin also said the same thing. There's been some legislation that was kicked around just within the past 24 hours in the Senate. I believe Senator Mitch McConnell, the minority leader, had asked for a unanimous vote to extend it out. I think they were looking for another $2 trillion and did not get the unanimous vote. And I believe the last I heard, which was about an hour and a half ago, they may have tabled that decision until this coming Monday. So who knows? I mean, things are happening very, very fast in the post coronavirus world. So we'll see what happens. But frankly, it would be hard to imagine that the government is not going to increase these grant programs just because of the economic impact we're having. It's going to be up to the politicians to get it done, which we'll see how that turns out.
Like from the landlord standpoint, managers have been tracking COVID-related expenses, disinfecting, cleaning, all the different things that are related to taking care of the building and the tenants with regard to COVID-19. What are the benefits of tracking those expenses?
Well, yeah, the benefits could be to the extent that you are allowed to pass through those expenses and you want to segregate them out, then you would definitely you should track those expenses. Also, some leases that I've looked at over the past couple of weeks for my clients, they specifically prohibit the landlord from passing through expenses that are used to clean up any type of contamination or hazardous substance. And then two of the leases I looked at in the past week specifically called out this type of contamination to be a hazardous substance. And in those leases, which we did not prepare, but in those leases, the landlord is not able to pass through those expenses. So the client, the project manager, is then having to go back and track all the expenses that they've incurred related to COVID-19 cleaning, because those cannot be passed through in every lease. Another benefit to tracking them, I guess, of course, tracking them because you can't pass them through is not a benefit, but it's a benefit to the extent that it helps you comply with your lease. Um, there could be some circumstances where you can file an insurance claim in connection with a COVID-19 incident, and if that occurs, then you would definitely have to track all of your expenses and all of your damages related to the COVID-19 issue. Now, before you rush out and start filing insurance claims, let me just warn you. So far, I haven't seen too many issues arise that would trigger a claim under most policies. But there are going to be a few that are out there, so it's definitely a case by case basis. So just because you've had contamination on your property does not necessarily mean that you have an insurance claim. But it's a good idea to track those expenses in case a claim does arise.
I want to break for just a second and let everyone know that if you have questions, please put them in the chat and we're happy to address them. I'd like to move forward and just ask a few more questions. So we kind of talked about this earlier, but I think this might lean toward a different answer. The question is, what do we do about tenants who utilize the CARES Act yet still don't pay rent?
Well, it's really up to the individual tenant. I will tell you that if they have utilized the CARES Act, they should at least be getting enough rent money to pay for the next couple months. So as long as they filled out the loan application properly and did it properly and timely, they should be able to pay the rent. So if they've told you that they've gotten the funds and they still can't pay rent, then I don't know there's a whole lot you should do with them. Of course, it's up to you and depending on your risk tolerance. But most of my clients and property managers I've talked to who have asked me this question, they have not been inclined to be very, very cooperative with the tenant when the tenant's asking for rent relief. Especially if they've taken the free money, so to speak, and not spent it on what it was supposed to be spent for. So with that being said, then the answer to the question is, if they don't pay the rent, then they're in default. And at that point, you can do whatever your lease allows you to do that you want to do.
Okay. Another question that's popped up: what is the most significant benefit to service providers with the CARES Act?
The most significant benefit to service providers is that is there any clarifications what service providers is? Is that?
There's no clarification, but if I can make an assumption, it would be those that provide services to our buildings.
Sure. Okay. The service providers. The good news about the CARES Act is the service providers are as long as they meet the requirements we talked about earlier, then they're eligible for the PPP. Even those companies who are self-employed individuals or independent contractors are also eligible for the PPP. And so, which is really good news because a lot of service providers don't have traditional employees per se. They have a lot of contractors. So you can still utilize these funds just like any other business can. And that includes even professional service advisors, the accountants, the property managers themselves. As long as they qualify, fill out the applications properly, they can also take advantage of the loan.
Awesome. I'm getting down to my last couple of questions here, but wanted to ask you are there any areas of concern that you have about the Act?
The one area of concern that I have about the Act is just from a legal perspective. There are a lot of parts to it that are not very clear, and people are interpreting it on the fly, and there's no legal precedent for the Act. There's no legal precedent for the Act, so it's hard to come back and give clients advice about how this may be interpreted by a court. So if there's one thing I would be concerned about is just what happens when the coronavirus issue wears off and life starts going back to normal and these loans start going into default. How's that going to be handled and interpreted, especially if now some clients I've talked to are being very, very aggressive with what expenses they're trying to get qualified in these loans. And so the questions will then become, what happens if those expenses are initially paid, but then later found out to be ineligible? And there really is no interpretation to help answer that question.
Yeah. All right, I have a few questions that have popped up.
Sure.
One question is, should demand and rent demand letters be sent per the lease, even if the tenant has communicated they can't pay due to COVID-19?
I would definitely send a demand letter, and I would still follow the letter of the lease. I would still send the demand letter and still follow all the proper protocols. Whether you decide to act on that is a different story. Keep in mind, there are restrictions on evictions right now, not only for residential, but also for commercial tenants. And so you can still send demand default letters. You can still have commercial lockouts, but you can't have evictions right now. You can still file lawsuits, but as long as you're not seeking to evict the tenant. But I would definitely still send out demand and default letters.
Okay, thank you.
Mm-hmm.
Another question, specifically, how is rent deferral viewed by CARES with respect to forgiveness of the loan? For example, if a tenant enters into an amendment with their landlord to defer May rent and June rent to be paid at a later date, will the value of the deferral be netted out of the grant amount?
If it's a great question. If the deferral is paid after June 30th, it is netted out of the grant amount. If you defer April and May and pay it by June 30, it's deferred. I'm sorry, it's forgiven.
Okay, good. This is a question with regard to just some of the actions that a lot of companies are taking. Is it actually legal to take an employee's temperature?
This if the employee consents to it, yes, but it's not. If you go around and start taking, you have to be very careful doing this, because if you go around start taking people's temperatures, there are so many issues with that. For example, are you qualified? This might sound like a silly thing to say, but from a medical perspective, are you qualified to actually administer that procedure? Are you qualified to read that? Are you sure that the equipment is valid? If you do that, if you take your employee's temperature and you're not a medical professional, you're violating the social distancing guidelines. So there's so many different issues with doing that. What I would recommend, now there are ways of taking temperature without making personal contact with somebody, but if you're concerned that employee is sick or maybe contagious, what you should do is you should enforce that with your guidelines about when employees are allowed to come into work. So, for example, if they're showing any of the symptoms, like a fever or whatever, they need to be told, and this needs to be enforced, that they have to go see a physician, or go get medical care to make sure they don't have any conditions that are contagious. But I would stay away from taking employees' temperatures. Again, if they consent to it expressly in writing, that may be an exception, but that still opens up a whole nother set of legal issues.
Well, what if the city of Dallas is requiring temperatures to be taken in order to be on a construction site, and are they doing that?
I have not, now again, unless something's changed this morning, but I have not heard of any such requirement to actually take temperatures. Obviously, if the city mandates it or the county mandates it, then they will have specific procedures for how that's supposed to occur.
Okay. Going back to the CARES Act, once the applications are submitted by tenants, how can we check the status? How can we check the status of both the PPP and the EDIL loan? I'm not sure what that is.
Yeah, this is one of these issues that's really kind of happening on the fly. It depends on where you submitted the loan through. A lot of the larger financial institutions, Bank of America, Chase, Wells Fargo, they've all have these online portals, and you can go in there and you can check the status of your loans. I have heard several complaints from clients and just other people who've tried to do this, where these systems are crashing. So, for example, the Bank of America system or the Chase system is getting clogged up because so many people are in this portal. Mm-hmm. And so, if that doesn't work, then you're going to have to just call your lender. A couple applications I was helping some clients with, their lender's business relations person was able to put us in touch with someone who was specifically handling the loan. And so we were actually able to call and find out the exact status of our clients' loans. And so that's probably the only way to really figure it out. There's, like I said, this is a new thing for the banks as well. Mm-hmm. And everyone's just kind of trying to learn on the fly. I bet you a week from now, I would have a much better answer for this question, just because so much is going to happen in the next 7 days as far as getting these loans processed, that we'll know the procedure a lot better.
Okay, good to know. Another question that's come up with regard to the loan, in regards to what part of the PPP loan will be forgiven. The June date keeps coming up. Does that mean any payroll, rent, and or utilities paid before that date will be forgiven? Nothing past that date? I think you may have addressed that, but can you?
Yeah, so the answer to that question is yes. Nothing past that June date. However, I certainly know, I can't predict the future like no one else can, but it would stand to reason that the federal government may move that timeline back, or you may move it later. I think it really just depends on a lot of issues, political issues, health safety issues. But yes, currently June 30th is the magic date, which frankly was that date was a compromise date by the politicians, but was put in there because that was kind of the prevailing thought of when things would hopefully start getting back to normal. I'm not sure, who knows if that's really going to be accurate or not.
And I know this is a question that you don't know the exact answer to, but do you think that if things take longer to get normal, that date would change?
I think it would change. I think it would be really hard. The government has gone so far to help people to do this. So I can't imagine that if things don't get materially better by then, that there wouldn't be some extension of that date.
Mm-hmm. Yeah. Well, to all of our registrants, I want to ask if anyone has additional questions. We've done a really good job of getting through them. I want to give you just another moment to type your message into the chat if you have a question. In the meantime, Tony, is there anything that maybe we kind of discussed earlier that you want to elaborate on, or that you think we should know?
It's a good question. I'm looking through my notes right now to see if there's anything else that I did not cover. No, I pretty much hit all the. I think I hit all the questions. Sorry, I just want to make sure that I didn't leave anything out. But I think I pretty much hit it all. So.
All right, that's great. Well, then I want to thank you first for the expertise that you give us. And it's definitely always a pleasure to be able to sit and talk with you and just share the knowledge that you have. I also want to thank everyone for joining us today and for everyone who submitted questions. And then I also want to thank our BOMA Greater Dallas Cornerstone partners for their support: April Building Services, AMST Elevator Interiors, Interstate Restoration, LandCare, Mooring Construction and Restoration. And then finally, we know that there's so much information that you need. So we'll continue to hold weekly seminars on topics related to COVID-19. Our next webinar on Monday, April 13, will cover effective ways to host a virtual meeting. Information on this webinar can be found on the BOMA Greater Dallas website under the event calendar. Tony, thank you again.
Thank you. Thanks, everybody.
Everyone else, have a great day, and thank you.